Let's go to number 4, keeping wills concise and to the point. And this one is great. I just had one of my colleagues come in yesterday, and they brought in this will that was 70 pages. And there was a trust that was an additional 70 pages. And let me tell you something, people. This is not the Woolworth family. This is not the DuPonts. These are probably just clients who could possibly get away with like a 5, 6, 7-page will, and you say, oh, I just charged the client hundreds, thousands of dollars, and now I'm going to give them a 7-page will, a 5-page will? The answer is maybe you should do that, because when I was reading War and Peace, I saw many problems. Number 1, first of all, this will was way too long. Number 2, there were contradictions. Number 3, there were things that had absolutely nothing to do with anything. This person who was a person who had drafted their will, a future testator, was 85 years old. They were not going to be starting a business. They were not going to be inheriting a business. Yet there was like a page and a half on if I have a business, a lot of ifs in there. Now I understand. Some of these provisions are probably useful, and every client will expect a little bit of expansiveness in the document. I don't want you to just throw in boilerplate, though, for a number of reasons. Number 1, it overwhelms the client. And remember, who's your first line of defense in catching a potential error or inconsistency in the will? You'll say you're a paralegal, and then you say, well, I don't have a paralegal. I'm a small practitioner. Got it. It's the client. The client is the one who's going to say, wait a minute, I don't have a child named George. You used your template. My child's name is Sylvia, and it isn't a he, it's a she. Great. Well, now you have a 70-page will. They're not going to be able to catch the, wait a minute, who is this trustee who, I have no idea who that is. When you overwhelm the client, you're getting rid of the first and foremost, most important person who can catch those errors and correct them. And again, you just say, I apologize, I made a mistake, as opposed to in the future, this is a big problem. Number 2 is this. Do not underestimate the clerks of the court. Now, when you start doing probates, you're going to get a little frustrated because you're used to things just going your way. I'm working with the client and I run the process and this is perfect and I say what goes and they say, whatever you say, Dan, I love it. You couldn't possibly make a mistake, which is what I want a client to think until I make a mistake. And then I say, well, occasionally I make a mistake, I'm sorry, and then we move on. But when you are doing probate, it gets a lot different and potentially difficult because it's not something you're always clear on. It's not a direct jump from drafting documents to probating documents. And they actually are going to disagree with you on occasion. Now, you can feel like you're right. It doesn't matter. It's a clerk. They're right. You have to kind of convince them, you're right, but here's another point of view, if you're pretty sure you're right and they're not. But more importantly is this. The good clerks will find mistakes. Remember, this is what they do. Now, I looked at one 70-page will yesterday and my eyes were just popping out of my head. This clerk has probably read 4 of them today. And even though it ticks them off a little bit, what ticks them off more is when they see errors and inconsistencies. When you have a super long will, are you sure everything that applied to one client is going to apply to a next one? A 70-page will is going to almost certainly at some point be contradictory within itself. I want you to take your time and cut out the wills and make it simple. Your boilerplate, like I said, may not be consistent. And last but not least, when you create a document that's too long, you create some type of consternation or maybe even distrust with the client. What's going on with this attorney? Why is he spending so much time? Do I need a 70-page will? I don't think I need a 70-page will. Believe me, his 85-year-old didn't need a 75-page will or 70-page will, whatever the case is. It leads to potentially resentment, but it also leads to potentially distrust. They feel like they're getting a boilerplate will. And guess what? They got a boilerplate will. So continue to draft your documents so that they are shorter and shorter and more concise and to the point. Plain English is a movement that they were speaking about in law schools 20 years ago, and yet the law has not done very good. And typically when I say the law, I mean lawyers. Lawyers don't do very well with keeping documents to the point.